Muri ora tātou, muri ora e hoama, tēnei te mihi maoha ki a koutou I runga I ngā āhuatanga o te wā. Nau mai ki tēnei hui, o te whakarewa o tēnei tohu, o tēnei rauemi, arā ko te Remediation Guidance mō ngā pākihi o tēnei whenua. Ka nui te koa, me te hari ki te kiti a koutou I tēnei rā. Ka toro atu ngā ringa manaaki o te kumihana tau hoko hoko ki a koutou katoa, hoi anō tēnei te mihi ki a koutou. Ko te tino whakaaro o tēnei tohu, o tēnei rauemi, o tēnei kaupapa, mā te tika te he e whakatika. Hoi anō, ko tērā te take, ko tērā te kaupapa o te hui nei. Māku he karakia ki te whakatūwhera. Tēnei hui, whai muri I tērā, ka tukuna te rākau ki te tumu whakarai, arā ko Vanessa. So welcome everyone to today's webinar for the launch of our remediation guidance. And before I hand over to our Chief Executive, Vanessa, I'll open us up with a karakia. Me noi tātou. E honore he kororia ki te atua, he mau ngārongo ki te whenua, he whakaro pai ki ngā tangata katoa. Hanga I te atua he ngā kauhau ki runga ki tēnā o tātou. Whakatongi atua wairua tapu, hei a whina hei toi a mātou. Hei ako hoki I ngā mahi mō tēnei rā. Kia ora rā, kia a koe Vanessa.
Tēnā koutou, tēnā tātou katoa, welcome. I'm Vanessa Horne, Acting Chief Executive of Te Kaumuhana Te Hokuhoku, the Commerce Commission, while Adrian Meikle is Acting Chief Executive up at Toitu Te Whenua, Land Information New Zealand. Thank you for joining us today on this webinar. I see we have 160 people online as well, which is great. Before we kick off, just a couple of little bits of housekeeping. So joining us this afternoon, you will hear from Andrew Riseley, Louise Unger, and Crystal Euden as they talk through our new remediation guidance and what it means for businesses. Some quick reminders first up though. Please ensure your microphone is on mute. And I will be running a Q&A session at the end of the panel's talk this afternoon. So if you've got any questions, please use the Q&A function on Zoom. And we're going to be leaving plenty of time for questions. So please start posting them as soon as you want to for our panel. I also just like to make you aware that we are recording this afternoon's webinar, and we will be publishing it following the session as well. But next, I'd like to introduce you just a little bit more to the Commission. So the Commerce Commission is New Zealand's primary competition, fair trading and consumer credit and economic regulatory agency. There are three main areas of work that the Commission undertakes in collaboration with many other parts of the public sector in New Zealand. Competition, where we're promoting competition in markets throughout the economy. Regulation, where we are influencing monopoly infrastructure performance for essential services, a growth area at the moment for us with some new functions in there. And of course, tackling harm from unfair trade practices and irresponsible lending. Our vision is that New Zealanders are better off when markets work well and consumers and businesses are confident market participants. Our vision guides our mahi and informs how we promote and deliver it to all New Zealanders. It's clearly grounded in our role in supporting markets to function and recognises that these markets must deliver long-term benefits for consumers, given all New Zealanders are consumers. We believe that improving business compliance is vital to protecting New Zealand markets. Businesses who have a compliance culture and customer focus don't wait for enforcement from the regulator, but proactively work to put things right. We've developed these remediation guidelines to empower businesses to act in the best interests of their customers. Businesses have told us that they wanted guidance on how to do remediation, so we embarked on a really thorough process to develop the guidance, incorporating as many views as we could, giving businesses the opportunity to provide feedback so we could take their views into consideration into this final version of the guidance. The Consumer Remediation Guidance helps businesses to put things right for consumers, after a likely breach of one of the laws that the Commission enforces. To ensure that the guidance suited the needs of businesses here in New Zealand, we sought feedback on the draft guidance via a submission process. We received a lot of great submissions and input, and we've used this feedback to incorporate into the final guidance that we're launching here today. All the submissions were also responded to in detail, and the document can be found on our website of all the feedback included. One feature of the process, and in alignment with our recently launched Utahi Māori, we've considered how Te Ao Māori can guide the remediation process. You will see a new section in the final guidance on this topic. We've taken inspiration from the Māori concept of utu. This emphasises the importance of maintaining balance and can be applied in both in the positive and the negative context. In the context of remediation, utu focuses on the need to put right a harm or a transgression, and that can include the repayment of a cost that has been incurred or a burden that has been borne in order to remedy the harm or transgression. The aim of that utu process is to restore balance and harmony in recognition of the obligations that exist between individuals and groups. We are hoping that this guidance assists traders to restore the balance in the relationships with their customers by engaging in that proactive remediation of the harms that have been caused. And now to introduce our guidance. This guidance is intended for businesses that have identified conduct or an admission that may have led to a likely breach of one of the laws that the Commission enforces, and where those businesses intend to take steps to address the issue, and where appropriate, offer remediation, whether that be compensation or non-monetary measures to affected consumers. A business may take steps to remediate an issue, and the Commission may subsequently investigate them for a breach of the law. Providing remediation to affected consumers will only form part of the Commission's consideration where a potential breach of the law has occurred. It won't prevent enforcement action from being pursued by the Commission. But businesses should take all reasonable steps to ensure that any identified breach of the law ceases as quickly as possible and that consumers do not continue to be affected, regardless of whether the business is going to undertake remediation or not. I'd like to hand over now to Andrew Riseley, General Counsel and GM of our Legal Services team here at the Commerce Commission.
Thank you, Vanessa. Tēnā koutou katoa. In the next few slides, I'm going to introduce our guidance, including why we've prepared the guidance and why we think traders should follow it. And then Crystal and Louise, in their presentations, will talk in more detail about the contents of the guidance. The first issue that I'd like to cover is what we mean by this term remediation, because it's not exactly a word that's in particularly common parlance. At its core, remediation is about putting right the harm caused to consumers by a trader's conduct or omission. In many or even most cases, this will involve putting consumers back in the position in which they would have been but for the likely breach of the law. For these cases, we can think of remediation as akin to compensation, a payment made to cover the loss or damage suffered by an individual where that is able to be quantified in money terms. This remediation will also often be accompanied by a payment of interest to reflect the time that's passed since the harm was caused, and potentially a further sum to reflect the inconvenience that the consumer has suffered. However, other types of remediation might not look like traditional compensation of individual loss or damage. For some types of conduct, for example, disclosure breaches under the Credit Contracts and Consumer Finance Act, it may be difficult to quantify the harm caused to consumers. In that case of disclosure breaches, the CCCFA provides for prescribed amounts of statutory damages, and so a lender that had committed a likely disclosure breach might proactively offer the amount of statutory damage that a borrower would be likely to be entitled to. For other types of breaches, for example, where electricity lines companies have levels of outages that exceed the quality standards in the Commission's determinations, it might be difficult to calculate the loss or damage suffered by an individual consumer. Instead, remediation in that case might mean providing a discount to all of your consumers to disgorge your gains or by making a contribution to a warm homes charity. So a one-size-fits-all approach can't be taken to remediation. On our next slide, we talk about what the guidance contains. Overall, it's a description of how to conduct a structured and consumer-focused remediation program. The guidance is centered around 9 principles, each dealing with a particular aspect of remediation. Between us, Crystal, Louise, and I will take you through each of these principles in this webinar. Note that they are principles rather than rules. So the guidance is not a remediation manual or a recipe book. The fact that they are principles reflects the broad range of circumstances in which the guidance might be used. This is because there is a wide variety of laws enforced by the Commission and a broad range of remediation outcomes that might be sought. However, in our view, the guidance around the principles is detailed enough to give a clear steer of what the Commission expects of a remediation exercise. In terms of intended use, the guidance and these principles are formally intended to be used where a trader considers that they have committed a likely breach of the laws and rules that the Commission enforces. However, we hope that they are good, sensible principles for remediation that might be suitable for many different types of potential legal breaches, or even more generally, where a trader thinks that something has gone wrong and it wishes to make things right. So why provide guidance? Well, Vanessa touched on this a bit before. It was really in response to stakeholder requests. The Commission has now had a fair degree of experience in looking at different types of remediation efforts by traders who've breached our laws and have proposed remediation exercises. But we had other traders, some of them self-reporting breaches to the Commission, who said, we would like to be in a position to proactively undertake a remediation exercise, but our board and our senior leadership team want us to be able to show that whatever remediation proposals we put in place are going to hit the mark in terms of what the Commission expects to see from remediation. And so that was a challenge that was laid down to us. And this guidance is intended to give a clear indication of the Commission's view on what good looks like. In our view, this is a win-win. It provides consumers with access to remediation at an earlier point than they would otherwise get if they had to wait for the Commission to insist as part of an enforcement process on remediation. And it provides business with the certainty of knowing what the Commission's approach may well be to remediation that they proactively undertake. Overall, we're keen to encourage good remediation practice on the part of New Zealand businesses. And we're hoping that the guidance can be used not just by traders and businesses, but also by external advisors to businesses such as lawyers and accountants. We know you have an important role to play in this process. Now, why follow the guidance? Well, the clear incentive that we give is that a trader's remediation program will be taken into account in the Commission's assessment of the appropriate enforcement response in the event that we do decide to investigate your conduct and take an enforcement approach. Our enforcement response is always informed by our enforcement response guidelines and our enforcement criteria, and those you can find on our website. One of the elements of enforcement criteria is the public interest. And it's clear from our ERGs and from our enforcement criteria that part of the public interest is whether a trader who has committed a likely breach of our laws has in fact taken steps to try and put that right. So what we can say with respect to the guidance is that you will always put yourself in a better position if you proactively take steps to remediate the harm caused to consumers in accordance with this guidance. But to reinforce a message that Vanessa made before, proactive remediation is not a get out of jail free card and will not prevent the Commission from taking enforcement action. It will absolutely be taken into account in terms of what the Commission does, And traders who have proactively remediated will always put themselves in a better position than those who do nothing. But it doesn't preclude the Commission from deciding in particular circumstances that formal enforcement action is still required. So as I said, there are 9 principles. Principle 1 is an overarching principle. And it says businesses who decide to remediate should take a genuinely consumer-focused approach. So what we expect to be able to see when if we do decide to investigate and consider your remediation program is that you've put consumers at the heart of your remediation program. What does this mean? Well, there are some indicators that are set out in the guidance and that are listed there on our slide. It means being proactive and helpful. It means communicating clearly with consumers using plain and tailored language. It means showing a commitment to remediate any loss or detriment. It means making the process accessible and free for consumers. It means being objective, unbiased, and fair to consumers in the way that you conduct the remediation. And it means the remediation program should have regard to the diversity of your consumers' backgrounds when you design and deliver the remediation process. I'll now hand over to Crystal to take you through some of the other principles.
Thanks, Andrew. Kia ora, ko Crystal Euden toka ingoa. It's my pleasure today to give you a brief overview of principles 2 to 7. In answering one of the questions we've already had from the chat, I'll also include some live examples of these principles in practice. Starting with principle 2, this principle is all about the lens from which a business should view and approach remediation. Our view is that businesses should undertake that remediation in a comprehensive, timely, fair, and transparent manner. But what do those mean? Let's break them down. Comprehensive means businesses should scope their remediation exercise to ensure that it identifies which consumers have been affected, how they have been affected, over which time period they were affected, and to what extent they've been impacted. All of this is useful and necessary, as truly understanding the harm helps to determine what is needed to put right the harm and prevent any further harm from occurring. Timely remediation is also key. Remediation should occur as soon as reasonably practicable after discovering the issue. As noted in our guidelines, remediation can take many forms, and it may be that different types of remediation are provided at different times. For example, when the Commission's Credit Branch is investigating initial disclosure breaches under the Credit Contracts and Consumer Finance Act, remediation of that breach can take several forms. The first and most timely remediation that we would expect to see is providing corrective initial disclosure to borrowers. This should happen as quickly as possible, likely before any financial remediation is provided. Another example of how types of remediation can occur at different times is in incorrect billing cases. The first and most timely remediation should be to fix the ongoing billing issue so that consumers do not continue to be overcharged. Again, that should happen as quickly as possible and likely before the business is able to organise any refunds back to consumers. Finally, timely considerations can also apply when considering who is paid back first in a pool of consumers. For example, businesses should consider prioritising remediation for those who are able to be remediated quicker. For example, if you're a bank and you're providing compensation to current and former customers, it would likely be reasonable for you to remediate current customers first because you are able to do so much more quickly. And this is often what we require in settlements under the Credit Contracts and Consumer Finance Act. Remediation should also be fair, taking a consumer-first approach and putting their interests and needs at the heart of the exercise. All of these considerations should help businesses consider which types of remediation are appropriate. Businesses may use different types of remediation concurrently, but again, if different types of remediation are being employed, then timing considerations are key. Turning to principle 3. This is the principle about how to calculate compensation. While remediation can take many forms, as I discussed earlier, this principle primarily deals with monetary compensation. In the guidelines, we mention the use of beneficial assumptions. These should be used where there are gaps in data or where a business wants to provide blanket remediation. In those instances, we expect businesses to use assumptions that are inclusive rather than restrictive. An example of this is in our recent settlement with Cooman Bank. As noted in the publicly available enforceable undertakings, which are available on our website, there were some customers for which Cooman did not have any records of having provided any disclosure whatsoever. Rather than arguing that it was more likely than not that those customers had received some type of disclosure, using beneficial assumptions, Cooman undertook to provide full remediation to those customers as if disclosure had never been provided. Turning to Principle 4, this principle is about the way that businesses engage with consumers, in particular, the way they communicate and what they communicate. Principle 4 asks businesses to communicate with consumers about the progress and outcome of the remediation in a clear, concise, timely, and effective manner. We have more on communicating about the outcome later, but this is just to say that businesses should let consumers know what is happening at the appropriate time. They should use plain language that is tailored to the language needs of the consumer audience. Principle 5 asks businesses to take best efforts to engage with and communicate with consumers. The guidelines make it clear that it's important for businesses to keep their consumers informed about the issues that affect them as they affect them. We do understand that it may be difficult to contact all consumers, especially where there may only be historical information on file that could be outdated. But by following this principle, we can be sure that businesses have made all reasonable efforts and can be satisfied that they've done all that is reasonably required of them to locate and communicate with their customers. In this principle, we also outline what steps you should take if you can't reach consumers, including the potential role of the Unclaimed Monies Act, which does feature in several of our settlement agreements available on our case register online. Turning to Principle 6, Principle 6 is similar to Principle 4, but focuses on the communication of the outcome of the remediation. Businesses should communicate what remediation is being offered and why, and should properly explain the consumer's rights. Those communications, as I mentioned before, should be clear and transparent. As an example, last year, Spark agreed remediation steps with the Commission in relation to the historic sale of Spark's wire maintenance service. Spark's website has a notice to consumers that is clear and transparent. It is about the remediation process and what customers can expect. The notice is still on Spark's website, so we would encourage you to check it out. Finally, from me, we're talking about Principle 7. This principle is about the way in which businesses actually provide remediation once they've reached that stage. The key here is for businesses to provide remediation in a convenient and accessible way, one that considers the needs of its consumers. For example, businesses should not require consumers to take unnecessary steps before they are remediated. In the example of a bank undertaking remediation to customers who have current accounts with the bank, it would not be convenient, for example, or accessible to require those customers to acknowledge the refunds before they are given. Refunds should just be made to the existing accounts without further delay. That's it from me for now, and I hope you enjoyed those practical examples. Louise will now talk to the principles relating to governance and record keeping. Over to you, Louise.
Thank you, Crystal. Kia ora tātou, ko Louise Unger, tuku ingoa. Right, as Crystal said, I'm going to cover principles 8, 9, and also talk a little bit about what the guidance says about seeking independent legal advice and our enforcement approach to remediation. So principle 8 relates to the governance for consumer remediation. The principle is that businesses should ensure that any consumer remediation processes have appropriate governance structures. So as we've already mentioned quite a few times throughout this webinar already, there is no one-size-fits-all in how businesses approach these principles, and governance is no different. The nature and the extent of the governance for the remediation program will depend on the size of the organisation and the particular remediation. However, although the processes and individual circumstances will be different, we suggest that businesses consider certain factors in determining the nature and extent of governance required. So one factor is the structure to support the remediation program and processes and oversight of this. So, for example, businesses should ask themselves and address the following questions. Who in the organisation needs to know about the remediation? Who makes the critical decisions about it? And who ensures that the way in which it is being run and what needs to be achieved is actually being challenged and questioned? More significant remediations may need to have the involvement of the executive team to provide management guidance and make decisions, as well as potentially the board or a subcommittee of the board to provide oversight of the program. Another factor to consider is that a remediation program should have appropriate resources to support it and be adequately resourced in order to achieve the other principles in this guidance. In particular, that the remediation can take a consumer-focused approach and is comprehensive and timely. So businesses will, of course, always need to balance the pool on resources for a remediation with other business requirements. That is just what happens. It will also need to balance the pool on resourcing to fix an issue with remediating customers impacted by that issue. And Crystal spoke a little bit about that in some of her examples. And one of those factors shouldn't be significantly compromised for the other. A further factor that Principle 8 mentions is that businesses should consider whether to report publicly on progress and outcomes. In our experience, public reporting at the outset and whilst remediation is underway assists consumers to know that they may be entitled to remediation if they have otherwise not been able to be contacted. Of course, again, it will depend on the nature and size of the remediation as to whether there should be a reasonable expectation for a particular remediation. The final factor I'm going to touch on in relation to Principle 8 is independent assurance. Independent assurance may be appropriate in certain circumstances. So, for example, very large consumer remediation programs, or where there is public concern because of significant or, in fact, widespread consumer harm. Typically, the independent assurance would take place by way of an audit at the end of the remediation process. It's worth noting here that if the Commission enters into enforceable undertakings or a settlement with a business as part of an enforcement outcome, it is quite common for the Commission to require independent assurance to be conducted across a remediation process. And just before I move on to Principle 9, I wanted to make a couple of comments about the synergies between Principle 8 and the Director and Senior Manager due diligence obligations in the CCCFA, which those of you online who are lenders or advisors for lenders will be familiar with. So the CCCFA due diligence obligation requires directors and senior managers to exercise the care, diligence, and skill that a reasonable director or senior manager would exercise to ensure that their business complies with its duties and obligations under the CCCFA. Amongst other things, in order to satisfy this due diligence obligation, the CCCFA requires directors and senior managers to have methods in place to systematically identify deficiencies in the effectiveness of their CCCFA compliance programs, and also to promptly remedy any deficiencies that are discovered. And our due diligence guidance, which you can find on our website, sets out our views on what lenders may need to do to satisfy the obligations to, in quotes, take prompt action where the lender has identified failures within systems and procedures. And this is aligned and consistent with the suggestions in our remediation guidance. So on to Principle 9 now. So this principle is that businesses should keep adequate records of any consumer remediation process. I don't have too much actually to add to what the guidance says in relation to this principle, as it's pretty comprehensive. I'm just going to really briefly recap some of the factors that the guidance outlines on what should be documented in order to have adequate record keeping in relation to a remediation. So the steps taken and decisions made in scoping and developing the process, the governance arrangements, communications with customers, all material decisions made as part of the process, the assessments of loss or detriment and basis for the remediation measures offered, progress against your timeframes for the remediation, and also details of the steps taken in respect of any unclaimed compensation. So on to seeking legal advice or independent expertise. So some remediations are obviously more complex or wide scale than others, and we recognise the benefit for businesses in seeking legal advice, or in fact other kinds of independent advice, to assist with the design or implementation of, in particular, these complex or large scale scenarios. So while we certainly don't suggest that independent advice is always required, it certainly may be useful in certain situations. We also recognise in the guidelines that businesses may want to actually consider seeking legal advice on whether to report the circumstances to the Commission or other regulators. So self-reporting breaches are one of the acts the Commission regulates, including the way in which the business intends to remedy that potential breach, is something that occurs in relation to a number of our regulatory systems. And now with my GM of credit hat on, self-reporting of CCCFA potential breaches is something that we definitely encourage in the consumer credit space, and that we take into account in determining any enforcement outcome. And we acknowledge that businesses will want to give due consideration to how they engage with a regulator in relation to potential breaches, and we certainly support the seeking of independent advice in these circumstances. And finally, on to the Commission's approach to remediation. So Andrew's already covered this a little bit in his section, so I'm only going to mention the specific remediation factors that are set out in the guidance. Although they're not exhaustive, they are ones that we will consider to guide our enforcement approach. So these are, firstly, how the issue was identified and how the business investigated the issue, including timeliness of these aspects. Secondly, the steps taken to identify, make contact with and communicate with consumers. Thirdly, the level of remediation provided or proposed to be provided to affected consumers. And then finally, the scale and seriousness of the issue and whether the business has had similar issues in the past. As Andrew mentioned, the facts of a particular case may actually mean that we do need to decide to bring proceedings, even if a business has remediated, or actually is just in the process of remediating, or has self-reported the matter to us. And in such cases, the extent of the remediation is a relevant factor for the court to consider in its consideration of any final penalty that is asked to impose. So we've now come to the end of our presentation of the guidance, and I'll pass back over to Vanessa, thanks, to facilitate our Q&A session.
Thanks, Louise, Andrew and Crystal. We've got a few questions that are coming through on the Q&A function on Zoom, but please feel free, those of you who are online, there's 199 of you, to pop some questions in there for our panelists. We've got at least 20 minutes, so we can start off with some that are there, but please, I encourage you to put some more questions on as well. So Andrew, there's a couple of questions in the Q&A that I think we can put together for you. But Andrew, what actions can be taken where a business fails to comply with the guidelines? Can the Commission intervene, or are there penalties or fines for businesses that obstruct or hinder the remediation process?
Yeah, good question, Vanessa. I mean, the answer is no, that these are intended as guidelines that are voluntary for traders to cooperate with. So if a business chooses to disregard this guidance and chooses to obstruct or hinder a remediation process, there's nothing that's provided for that we can do in terms of penalties or fines. But what I can say is, in the event that the Commission investigates, and in the event that the Commission is considering an enforcement response, a failure to comply with the guidance, and in particular a situation where there was obstruction or hindrance of a remediation process would absolutely be considered in a detrimental way. So the Commission may well decide that a more serious enforcement outcome is necessary where there hasn't been any attempt to remediate, and where a business has actually sought to obstruct or hinder. It may well mean that we that we decide that we do need to bring proceedings or file charges, and we do need to make the court aware when it's considering any penalties that it should be imposing on someone about the trader's conduct during that process. So it's important to say that there's nothing that immediately happens if you fail to follow the guidance. But in the event that there is an investigation enforcement, a failure to follow the guidance can have real consequences.
Andrew, we'll just stay with you for a minute, if that's okay. There's a question that's popped in. We're not alone in remediation of things like this, but how does this guidance align with something similar that the FMA or other regulators may have put out?
So we have definitely made sure that we've provided the FMA with copies of the guidance, and so they've been absolutely aware of the process. And I understand that they are themselves considering a similar type of guidance. We know that there's guidance that ASIC, the Australian Securities and Investments Commission, has produced for traders who are active in Australia. And in the event that we do end up with guidance from the FMA, we're quite conscious that we have stakeholder and regulated entities in common. And so we'd make sure that we would revise our guidance to take account of anything that the FMA was saying. But I can assure people who deal with us both that the FMA is absolutely aware of the guidance, and I believe is looking at it quite closely.
That's great. Thanks, Andrew. Louise, one for you. Can businesses seek guidance from the Commission if they're unsure whether their conduct or omissions have led to a likely breach of one of our laws?
Yeah, again, a good question. So the Commission produces a whole range of guidance around the various laws that it enforces in relation to its views on how businesses should interpret that guidance, interpret those laws and apply those laws. The Commission is not, I suppose, in a position to be able to provide legal advice on specific fact scenarios and questions. But what we do definitely welcome dialogue in relation to particular areas where businesses feel that there's interpretation issues of the laws we regulate, or where there's some uncertainty, and in particular situations we can, and particularly where those questions relate to industry-wide concerns or issues that arise in relation to particular scenarios that might apply to more than one business or a group of businesses. We definitely can and are keen to provide guidance in relation to those particular scenarios, and we'll try to do that more widely where we can. So, for example, in the credit space, we engage quite regularly with particular parts of the industry or particular industry associations. We also provide some of our perspectives through Q&As on the website, as well as what we call our lender Pānui. But in terms of individual fact-based scenarios, no, we can't provide guidance on those, and that those scenarios will usually be left to if we're investigating a particular fact-based scenario.
Right. And if you haven't signed up for all of those resources that do come out of the credit part of the Commission, I encourage you all to do so as well. One for you, Crystal. What mechanisms are there for consumers to communicate and give feedback on the process of remediation or of remediation efforts to the Commission?
There's probably three parts to that answer, Vanessa. The first being that the primary place that consumers should go to for feedback is the business providing the remediation plan. That is particularly where the business is undertaking its own remediation plan without any involvement from us. Now, if we are involved, then of course we'd be interested to know about any issues to do with remediation, and that's consistent with some of the settlements and forcible undertakings that we've been involved in to date. But other than that, I think if we're not particularly involved in, say, an investigation that's led to the remediation or something like that, then I think it's fair to say that we'd be interested in general feedback that would be helpful for all industry, but wouldn't particularly look to involve ourselves in specific remediations that businesses were undertaking on their own.
Yeah, thanks, Crystal. Why don't we put this one out to all of you, actually? So apart from the considerations of time, what would you say to smaller businesses who might be disproportionately affected or find it financially onerous, burdensome to implement the guidelines comprehensively? What are your sort of tips for them?
Well, I can kick it off.
Go for
Do you
it, Crystal.
want to start with that one,
Yeah.
Crystal, and then I can
well,
I can add to
I'll
it?
try and answer all the question and then leave you with nothing to add. That'll be my goal. Essentially, it's a substance over form, I believe. The principles are there as guidance, but at the end of the day, the heart of the principles are that consumers are the focus. I think it will be fact specific and it will absolutely be size of trader specific. But we've been involved in a number of different remediations, from very small businesses to very large ones. And there are lots of different factors that come into play depending on the size of the business. For example, how long you have to pay customers back, the types of communications you might want to put out to your customers, etc. So what I would say is the principles are broad enough to allow you enough room to target and tailor a remediation plan for your specific business.
Anything else to add, Andrew or Louise?
Well, as Crystal said, she wouldn't leave me much to talk about. But look, I'd just reiterate that again, I'd be suggesting to small businesses, you still consider all of the principles. The principles should apply across the board, regardless of the size of your business or the nature of the remediation. But then, of course, the specifics and the detail that we've provided in the guidance that relate to each principle, some will apply to smaller businesses or smaller remediations and some won't. And I think the reality is the larger your remediation is and the more complicated it is, the more we would expect to see the various aspects of our remediation guidance really being considered and being applied to that remediation.
Great, thanks, Louise. Anything on top of that, Andrew?
I think they were very good.
No. So Andrew, let's stick with you though. What incentives would businesses have to preemptively act where they will have to allocate resources and may also have to publicise the process, potentially affecting their reputations?
Yeah, so I think we would see the incentive to act as kind of twofold. One, it puts you in a better position in the event that the Commission comes calling and investigating and deciding on enforcement action. Just to reiterate the point, you put yourself in the best position possible if you can show that you've remediated and you can show that you followed the guidance. And so, so that's hopefully an incentive. More broadly, I think good remediation processes should be good for traders' reputations. If you've put up your hand and acknowledged that something has gone wrong, but that you are doing something proactively to fix it, you're not waiting for a regulator to come and tell you that it has to be fixed. You're not waiting for a court to tell you and order you to do it, but that you're actually putting your hand up and saying, this has gone wrong. And because I care about my customer base, I'm going to do something about it. That I think resonates well with consumers. There's a degree of cynicism, I guess, amongst consumers at the moment. The cost of living means that that everyone's looking out for every penny, and I think a business that followed the guidance and recognised proactively that it had a need to put something right would put itself in a good position.
Yeah. Thanks, Andrew. Crystal, there's been a couple of questions about what's a reasonable time frame, things like that. Though assessment of all timeframes are going to be very fact dependent, are there any examples of previous remediations that might offer some guidance about what might constitute a suitable timeframe? Any tips you can pass on to the audience?
Yeah, I'd say a rule of thumb is probably the smaller amount, the less time you have to pay it back, and the larger amount, the more time you have to pay back. I think another fair rule of thumb is, depending on how many current customers you have, you probably have less time to pay it back because they're more easily able to be located and refunded, versus if you've got a historical ledger of people that need to be refunded, you probably need longer. In terms of some specific examples, I'm going to plug again, our case register on our website has a plethora of different examples, and I would encourage you or any businesses who are looking at how long they might need to pay to have a look at that. A really good example is Commun Bank, who we entered into enforceable undertakings and a settlement agreement with relatively recently. Commun Bank had about $11 million to refund, and there was a split in the enforceable undertakings vis-a-vis current and former customers. So current customers were required to be refunded their amount within 4 months, and then former customers, there's effectively a period of 2 years within the agreement in which Commun has to hold their credit on their behalf while they try to locate the former customer. Another one to maybe check out for businesses who are interested in more specific examples is probably the Moolah fee settlement that is, I think it's a good couple of years old now, but you'll see in the documents in our case register that the refunds were able to be given back in tranches, and part of that was to allow the business time to get that money together to refund it, but also allow the business to work out who was entitled to what and appropriately time their remediation.
Can get quite complex quickly, I suspect. Andrew, keeping up with the remediation and action that the Commission's taken previously, you mentioned the Spark remediation situation case. The question is it considered acceptable to place a notice on your website and ask a consumer to self-identify if they have been impacted?
Yep. Well, and the answer is it depends. There will be situations in which you don't necessarily, as a trader, have contact details for consumers who are affected, in part because they might be former consumers and they may well have moved on. The guidance does provide some hints for businesses about what we'd expect them to do as part of a consumer-focused remediation in tracking down former customers. In situations where you have current customers who have been affected, we definitely wouldn't regard it as acceptable to simply put a notice on your website and expect the customers affected to come to you. Part of being consumer focused is making sure that consumers are aware of their rights. But we're realistic. There may well be situations in which it is hard to track people down. Crystal's made a number of references to the case register, and in fact, if you go back through some of the settlements and enforceable undertakings that the Commission has struck with traders, there are hints there about the types of steps that we would expect traders to undertake to track down people. So it may well be that simply putting a notice on your website won't itself be sufficient, but putting a notice on your website might well be part of the process as a kind of a safety net for customers that you're not otherwise able to track down.
So Louise, sort of in a similar vein, there's been a question of, for remediation purposes, how long must we hold client information?
Yeah, another good question. So we recognise that there's certain requirements to during the course of a business, destroy information or not hold it for longer than is required. And obviously the Privacy Act is a good example of that. But I suppose we would be suggesting, and I think we do so in our remediation guidelines actually, that where a business becomes aware of a particular issue and they realise that they may need to face into potentially a compensation scenario or some form of remediation, that would certainly be suggesting that they put a hold on the destruction of all documents that are likely to be relevant to that remediation, including information relating to specific customers that may be affected, so that that can be used in determining the right outcome for customers, tracking down customers, how they've been impacted, all of those things. I think, no expectation, obviously, because there are particular laws in place that a business forever holds information on the expectation that they might need to do a remediation, but and a strong recommendation by us that you don't destruct useful and important documents that are relevant to a remediation program once you identify a potential issue.
Thanks.
And Vanessa, just to kind of add to that, of course, if you're in the process of undertaking a remediation exercise while the Commission is investigating, then it is important to hold on to the records that show what you've done with respect to remediation. So we're able to effectively give you credit for all of that and to see what you've done. And as Louise alluded to, there's quite a bit of detail in the guidance about record keeping with respect to the remediation that's actually been undertaken.
Which, Crystal, really nicely goes to a question for you, actually. So is there any guidance around the trigger for a business, whether they need to consider to undertake a remediation process? If they've received a lot of complaints, what triggers this sort of thing for a business to think about?
Yeah, so I like to call them red flags. So I think every complaint can be treated as a red flag, and a series of complaints certainly should trigger what I would call a rectification stage at least, and then a remediation phase to probably follow after that if it's identified that as a result of issues that have been founded from complaints or, the business's own auditing of its practices and things like that. The first thing I'd say is, we talked about timely parts of the remediation being key. Remedy the problem, resolve the problem first. If it's a billing case, make sure customers are now paying the right amount, and then look to, have customers lost anything? Is remediation appropriate? So I would say absolutely use your complaints data. I would encourage lenders, for example, to do responsible lending audits, to have a look at, what are their default rates like within a few months of entering into loans, stuff like that. Use that to your advantage, and then trigger probably a two-step. Is there something to fix, and then is there something to pay back?
And while you've got there's a question about the de minimis amount footnote on footnote 13 on page 7 of the guidance. We love footnotes. Do you want to talk a little bit more about that one?
Yeah, unfortunately, we can't put a number on it because it really will depend. In my time at the Commission, I've seen everything from $5 being a de minimis amount to $20 to even more than that. But where it's been significantly more than that, it's been part of a conversation with the customer whether they want the money returned or the money paid to charity or something like that. So it really will depend. At the end of the day, if you're for example, you're in a business where we're talking small amounts, then small amounts matter to people. Equally, if you're talking large amounts, who are we to say that $100 is de minimis? It really is going to depend on the business that the service you're providing and the customers that are in your book.
And just to add to that, Vanessa, obviously the footnote talks about various factors that are going to be relevant to that, and clearly the cost of making the payments is an important factor. So we can understand the approach of saying, I'm not going to spend $10 in order to pay someone back $5. But in some circumstances, the right answer might be, well, you just have to bear the $10 in order to get the $5 back to someone. But being able to show that you have that information, that you've considered it, that you've come to a reasonable position, is all part of documenting what you've done with respect to the remediation.
Yeah, a massive factor is how easily and quickly can you give the money back. You know, if it's difficult, it's going to cost a lot of money, then a de minimis is probably relevant. But if they're a current customer with a current transaction account and you only owe them $1, it's not going to be hard to pay them $1.
I'm quite conscious of time here. We might just do one more, and then we will call this to a close. I think the team are hoping to get some further answers to some of the questions that we haven't quite managed to answer out to members of the audience as well. So, Louise, last one for you. Can the business set time limits for the affected consumers to come forward and claim things under their remediation process?
I might have to defer to Crystal on this one.
Oh.
Look, I'd say no. Not really. No. There has to be a reasonable approach to that, and you know, you have to give customers quite a lot of time to be able to sort of come forward and to be able to work through that remediation. But of course, there does come a point where if money is unlikely to be claimed, I'll have to get Crystal to talk to, because she's far better than I am to talk to the unclaimed monies requirements that might trigger the need to actually identify money as unclaimed money, and in which case the business is then under certain obligations under the Unclaimed Monies Act to provide that money to the Inland Revenue Department, or in fact to make a decision that actually that money should be provided perhaps to, if it doesn't fall into that bucket, maybe to provide it to a charity or elsewhere, in order to still make a reasonable attempt to not profit from the mistake that's been made, but equally do something with it.
I think piggybacking off that really nicely, I'd just add that we understand that businesses will need to draw a line in the sand somewhere, and we often in our agreements provide it's anywhere between 2 or 3 years that amounts are held on credit. But businesses also have to consider their obligations under the Unclaimed Monies Act, and that is the IRD will accept amounts paid to it earlier, so unclaimed monies paid earlier than the 5 years in the statute, but we would only recommend that if the amounts are over $100. That is because the IRD is only required to hold amounts over $100 for a person. So if you're paying over, a raft of amounts underneath that, that's getting paid straight to the IRD. In that case, you might want to consider, if you've held it for an appropriate time, a couple of years, 3 years, depending on the matter. Like Louise said, you might want to consider paying it to a charity that you're not associated with, that is a link in some way to the breach. So, for example, if it's a lender, we encourage charities to be considered that assist borrowers in financial need and things like that.
That's a great example. Yeah. We're at 3:30. I want to say a big thank you to Andrew, Crystal and Louise, of course, for pulling the seminar and the remediation guidelines together, but to all of you for joining us today. And if you've got further questions, please reach out to Louise and team. And I'll hand over to Wiremu to close us out this afternoon, but thank you all for joining us.
Kia ora no e hōma, mihi nui ki a koe te rangatira, e Vanessa, mihi nui ki a koutou katoa, ka taia ki tēnei hui, i tēnei ai. Ko matunga kōrero mō tēnei wā, māku he karakia ki te whakakapi. Mi noi tātou. E taunga manaakitanga te mea ngaro, ki runga ki tēnā o tātou. Kia mahia te hua mā ki, kia toi te kupu, toi te mana, toi te aroha, toi te rau Māori. kia tuturu ka whakamaua kia tina, haumi e hui e, tae ki e. Mā te wā.